Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of civil procedure, constitution and contract. To know more about them, please watch the video fully. In the important judgment titled Indian Ex-Servicemen Movement and Others versus Union of India and Others, pronounced on 16th March 2022, the Supreme Court has upheld the one rank one pension scheme in defense forces introduced by the Union government to bridge the gap between the rate of pension of current and past pensioners at periodic intervals. The facts of the case would be that the one rank one pension, which always entailed an automatic revision of the rates of pension to bridge the gap in the pension being received by the past and current pensioners, was planned to take effect from 1st July 2014. However, a letter of the Joint Secretary of the First Respondent to the chiefs of three defense forces introduced a revised definition of one rank one pension, where the revision between the past and current rates of pension was to take place at periodic intervals. Later, the rates of pension were then to be revised every 5 years. By its letter, the first petitioner objected to the revision of the definition of one rank one pension, highlighting that the deviation from the automatic revision of rates of pension to a revision at periodic intervals changed the accepted meaning of one rank one pension. It was also submitted that the revised definition would deprive the past pensioners of equal monetary benefits, which militated against the principle of one rank one pension. That led to the filing of petition under Article 32 with an issue posed for consideration whether revision of the definition of one rank one pension and its implementation in the present form is arbitrary and violative of Articles 14 and 21 of the Constitution. The Supreme Court has summarized the principles relating to pension and cut-off dates that all pensioners who hold the same rank may not for all purposes form a homogeneous class. For example, among sepoys differences do exist in view of the modified assured career progression and assured career progression schemes. Certain sepoys receive the pay of the higher ranked personnel. The benefit of a new element in a pensionary scheme can be prospectively applied. However, the scheme cannot bifurcate a homogeneous group based on a cutoff date. The judgment of the Constitution Bench in D.S. Nakhara versus Union of India, reported in 1983 AIR 130, cannot be interpreted to read the one rank one pension rule into it. It was only held that the same principle of computation of pensions must be applied uniformly to a homogeneous class, and it is not a legal mandate that pensioners who held the same rank must be given the same amount of pension. The varying benefits that may be applicable to certain personnel, which would also impact the pension payable, need not be equalized with the rest of the personnel. Applying those aforesaid principles to the facts of this case, this court finds no constitutional infirmity in the one rank one pension principle for the reasons that the definition of one rank one pension is uniformly applicable to all the pensioners irrespective of the date of retirement. It is not the case of the petitioners that the pension is reviewed automatically to a class of pensioners and periodically to another class of pensioners. The cutoff date is used only for the purpose of determining the base salary for the calculation of pension. While for those who retired after 2014, the last drawn salary is used to calculate pension. For those who retired prior to 2013, the average salary drawn in 2013 is used. Since the uniform application of the last drawn salary for the purpose of calculating pension would put the prior retirees at a disadvantage, the Union government has taken a policy decision to enhance the base salary for the calculation of pension. Undoubtedly, the union government had a range of policy choices, including taking the minimum, the maximum, or the mean or average. The union government decided to adopt the average. Persons below the average were brought up to the average mark, while those drawing above the average were protected. Such a decision lies within the ambit of policy choices. While no legal or constitutional mandate of one rank one pension can be read into the decisions in D.S. Nakara versus Union of India reported in 1983 AIR 130 and Union of India versus SPS Vains reported in 2008-9 SCC 225, varying pension payable to officers of the same rank retiring before and after 1st July 2014, either due to modified assured career progression or the different base salary used for the calculation of pension cannot be held arbitrary, and since the one rank one pension definition is not arbitrary, it is not necessary for this court to undertake the exercise of determining if the financial implications of the scheme is negligible or enormous. Coming to the next important judgment, titled State of Punjab and Others versus Devraj Sharma, pronounced on 16th March 2022. In this judgment, the Supreme Court has held that under Section 7(1) of the Court Fees Act 1870, ad valorem court fees would be payable on the amount claimed if the suit is a money suit for compensation and damages. The facts of the case would be that the respondent instituted suit for recovery of rupees 20 lakhs as damages suffered by him on account of denying the status of freedom fighter and also for the loss of reputation on account of non-issuance of certificate of freedom fighter. The valuation of the suit, both for the purpose of court fees and jurisdiction, was fixed at more than rupees 20 lakhs, but court fees of rupees 50 was affixed relying upon a judgment of the Punjab and Haryana High Court. An undertaking to pay the court fees on the sum to be adjudicated as damages by the court in due course of time was also stated. The defendants preferred an application under Order 7 Rule 11C read with Section 151 of the CPC on the ground of non-payment of requisite court fees. The trial court directed the respondent to file the court fees on the amount of rupees 20 lakhs as claimed by him and granted about 10 weeks' time. Allowing the revision petition filed by the plaintiffs, the High Court held that as the actual and specified amount of damages was still to be assessed and determined by the trial court, as such, the direction of the trial court to pay ad valorem court fees on the amount of rupees 20 lakhs was not sustainable. The High Court also noted that the plaintiff has undertaken to make good the court fees on the amount adjudicated as damages by the court in due course of time. Being aggrieved, the present appeal has been filed with an issue posed for consideration whether the suit in question as framed was a money suit for compensation or damages falling under Class 1 of Section 7 or was a suit falling in any of the categories specified in Class 4 of Section 7. The Supreme Court has held that Section 7 provides for computation of fees payable in certain suits. Subclass 1 refers to money suits, which include suits for damages, compensation, arrears of maintenance, annuities, or other sums payable periodically, where the fee payable would be according to the amount claimed. Further, Subclass 4, which has further 6 categories, namely suits for movable property of no market value, to enforce a right to share in joint family property, for a declaratory degree and consequential relief, for an injunction, for easements, and for accounts. The fees on a suit falling in these categories would be payable according to the amount at which the relief sought is valued in the plaint or memorandum of appeal. It also states that in all such suits, the plaintiff would state the amount at which he values the relief sought. A reading of the relief clause would show that this was a money suit for compensation or damages and not falling under any of the categories mentioned in clause 4 of section 7. Therefore, there would be no question at all for the applicability of section 7.4. It would be a simple case of applicability of section 7.1, and ad valorem court fees would have to be paid as per schedule 1 entry 1. Once the suit in question was a money suit for compensation and damages falling under class 1 of section 7, ad valorem court fees would be payable on the amount claimed. In the present case, the respondent has not given a separate valuation for the relief sought, and rightly so, as it had no liberty and right to give different valuation than what was being actually claimed. As a matter of fact, in para 11 of the plaint, it is clearly stated that the valuation is the same for court fees and jurisdiction. The valuation for the purpose of jurisdiction and relief has to be the same in the money suits falling under category 7.1. It was only in category of suits covered by class 4 of section 7 that there could be two different valuations for the purpose of jurisdiction and for relief sought. The High Court therefore fell in error in setting aside the order passed by trial court, whereby it granted time to the plaintiff respondent to make good the court fees within a particular period, failing which the plaint would stand rejected. The judgment and order of the High Court is set aside and that of the trial court is restored. Now we are going to deal with the important judgment titled NG Projects Limited versus VINOD KUMAR Jain and others, pronounced on 21st March 2022. In this judgment, the Supreme Court has held that a court should refrain from interfering in the grant of tender even if it suffers from total arbitrariness and malafide. It should instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The facts of the case would be that the Road Construction Department of Jharkhand invited tenders for construction of road. Respondent number 1 participated in the tender process and also submitted bank guarantees as bid security. The Tender Evaluation Committee held a meeting for technical evaluation of bids, and 13 out of 15 bids were held to be non-responsive, including that of respondent number 1. However, the technical bid of the appellant was declared to be substantially responsive, and after due evaluation of its financial bid, work contract was issued to the appellant. The appellant started the work on the stipulated date of commencement and completed earthwork for 21.9 kilometers out of 24 kilometers proposed road. Respondent number 1 filed a writ petition for quashing of decision of Technical Evaluation Committee holding its bid to be non-responsive. The single bench passed a common order in respect of 2 other works and the work in question, setting aside award of contract granted to the appellant. The division bench dismissed 2 appeals against 2 other tenders. However, in appeal against the work in question, the division bench noticed the fact that the appellant had already started the execution of the work and that part of the work had already completed, but held that there was no valid distinction with the case of other 2 works against which latter's patent appeal was dismissed. Being aggrieved, the present appeal has been filed. The Supreme Court has held that it is patently clear that if the format for a bank guarantee is an essential condition of the contract, the format in which the respondent opted to submit it is a substantial variation in the terms of the contract. If the variation done by respondent number 1 is considered to be acceptable, then it would create a burden on the tendering authority to ensure that each underlying bank guarantee is valid, and further to consider whether the amendment letter itself was with the full knowledge and consent of the bank. As it were, on the facts of the case, the state informed the High Court that it attempted to verify the amendment, but there was no response from the bank. This being the case, it is submitted that the relaxation in the format to bank guarantee was rightly not provided to the respondent. The Specific Relief Act 1963 was amended by Central Act 18 of 2018 when Class HA was inserted in Section 41 to say that if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of the relevant facility related thereto or services being the subject matter of such project. Since the construction of road is an infrastructure project and keeping in view the intent of the legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provision should be kept in view even by the writ court while exercising its jurisdiction under Article 226 of the Constitution of India. The satisfaction whether a bidder satisfies the tender condition is primarily upon the authority inviting the bids. Such authority is aware of the expectations from the tenderers while evaluating the consequences of non-performance. In the tender in question, there were 15 bidders. Bids of 13 tenderers were found to be unresponsive. The writ petitioner was one of them. It is not the case of the writ petitioner that action of the Technical Evaluation Committee was actuated by extraneous considerations or was malafide. Therefore, on the same set of facts, different conclusions can be arrived at in a bona fide manner by the Technical Evaluation Committee. Since the view of the Technical Evaluation Committee was not to the liking of the writ petitioner, such decision does not warrant for interference in a grant of contract to a successful bidder. The writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. The court should be even more reluctant in interfering with contracts involving technical issues, as there is a requirement of the necessary expertise to adjudicate upon such issues. Even if the court finds that there is total arbitrariness or that the tenderer has been granted in a malafide manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract. The action of the respondent in setting aside the letter of acceptance granted to the appellant suffers from manifest illegality and cannot be sustained. Consequently, a direction is issued to the respondent state to allow the appellant to resume and complete the work by excluding the period spent in the stay of execution of the contract.